this video, we're going to take a moment and really we're just going to briefly discuss what we call here in Texas House Bill 4063. It came down, went into effective September of 2025. And what this deals with is these wonderful things called Memorandums of Contract, maybe an Affidavit of Contract. And just a brief history, y'all. You go back 2-3 years ago, memorandums of contract really didn't exist. It wasn't until everything got so exacerbated where a investor would go meet a seller at 10 o'clock in the morning and go to contract. And another investor comes in right behind them a few hours later, tells the seller they can give him more money, and that seller who wants more money signs that contract. Now, when you do that, by the way, that second investor is interfering in contract because we all know they have actual knowledge of the first contract. Otherwise, how do they know they're going to outbid them? And then sometimes, at 3 o'clock in the afternoon, investor number 3 comes in. They do the same thing all over again. The problem is with these investors who do this, it's all about making money. They don't care about the seller. They just want to get a deal done. They want to try to outflank the first guy, and sometimes it just doesn't happen. So of course that means they go running back to the seller to renegotiate their deal, and it is a mess. It was great years ago when these things really didn't exist, and today to me it's all about greed, unfortunately, and investors who think they can do more than the other guy or better, and that they're really helping the seller when they're really not doing it. Also, what happens so often is that these investors who do this, they might get an actual signature of the seller who owns the property, but maybe there's multiple heirs and they get one, and they think they have some ownership, buying from that one heir for the entire price of the property. It's a mess, and Texas has tried to clean it up a little bit, and so I'm just going to touch base briefly on this. I'm going to try to get with my other counsel in office and try to expand this a little bit later on as well, but let me kind of walk through the highlights. One of the things I like to do first and foremost is if I'm going to file a memorandum of contract, I want to attach my contract for sale to that property to show I actually have a signed contract. I want to show and identify what title company maybe it has been delivered to, so that somebody can truly verify there is a real contract that's actually been delivered to a title company, that earnest money has actually been paid, to validate the situation, other than just filing a piece of paper saying, hey, I got a contract, here it is, thank you. And that is what so many investors do. They want to shortcut everything as fast as possible to try to tie up their position. And by doing this, they've created this wonderful menagerie out in the marketplace. So the state came in and they proposed and passed this House Bill 4063. And what it basically does for us is it says that if you are an investor and you are going to file a unilateral memorandum of contract or a unilateral affidavit of contract, you've got to file it in deed records. You've got to make sure your mailing address on there that's accurate and correct. Your phone number should be on there. You've got to make a copy of that and a notice letter and provide all of that to the homeowner by certified and regular mail so they actually get it. And then on top of that, you've got to provide a certificate of mailing, which is a sworn affidavit saying, I prepared this and I sent this to the homeowner that's out there. And you have to make sure that you send it to the right address. Now, if the person who purports to own this property doesn't live at the property, you don't just send it to the property. You're going to send it to the actual address for that investor. Okay, that's awesome. But remember, it's unilateral. That homeowner has the opportunity to then file what we call a contravening affidavit. And they can then file that into deed records stating that that memorandum is not accurate. And it stipulates that they're supposed to state why it's not accurate inside of the affidavit as filed. just like in the first part, that homeowner is supposed to send it to the investor who filed the memorandum with a notice of mailing by certified or regular mail, and then file in the deed records again a certificate of mailing of that. So you're going to take not your memorandum, you're going to take your notice letter to the homeowner or to the investor, you're going to take the certificate of mailing, and you're going to record all that in deed records. And so it starts with the investor with this unilateral memorandum. And by the way, guys, unilateral simply means one investor signs the thing and that's it. No one else is a party to that document. They file their affidavit in deed records saying, hey guys, we have this memorandum, it's out here. We've done all the things pursuant to this bill we're supposed to do. Homeowner can then controvert that and file that as well. Now, if you've done that and then the homeowner sells the property to a third party, the purchaser is not going to have any liability to anybody else along the way. It's going to act as a filing of fact that they don't have to rely upon the memorandum for any purposes whatsoever. A title company or a lender doesn't have to rely upon that for the purposes of clouding title in some format. In those situations, the investor is only going to have a money damage issue against the seller in that case. That means you don't get the property back. You can sue that seller for damages. And as we all know, good luck doing that in most cases, because that money, whatever that money was, has gone poof and it's probably gone. That seller is probably gone. Now, the investor, if you want to take it, excuse me, take this to the next level, comes in and they can file their contravening affidavit as to the homeowner's contravening affidavit. So it's kind of a tit for tat going on. Again, starts with the investor filing their memo, following the steps properly, proper mailings, proper recordings in the deed records. Then the homeowner can file their contravening affidavit, and then the investor can file their contravening affidavit stating why the homeowner is incorrect. And guys, if you don't follow the rules exactly the right way, this thing is void, and it's not going to have to be followed by anybody along the way. And I believe that the investor who filed the initial memorandum has 45 days to file their contravening affidavit if a seller files theirs. So it's out there to protect the homeowner from these investors who just file these memorandums, to protect title companies and lenders and future buyers, where it's just tying up properties needlessly, where investors are holding homeowners hostage. Well, I'm not going to release my memorandum, even though it may not be correct, unless you pay me money, X amount of dollars. And it seems to be so prevalent, even though they're in the wrong, they still do this and hold people hostage. It is completely wrong. It's incorrect. It's a blight on our industry. And personally, I don't like it. But if you're going to go to that extent and you're going to file a unilateral memorandum of contract, follow the rules and regulations. Include a copy of your contract, in my opinion, as part of that filing to verify and validate you have a legitimate contract. Include the title company contact information in your memorandum so that a third party can contact someone to also verify that. We all know investors throw out addresses or P.O. boxes that you can't really get things, you can't serve somebody supposedly in that regard. But it's good enough for mailing purposes. And sometimes their phone numbers are out there that suddenly get disconnected or they're gone. And we're tied up with this memorandum that no one can release, and it creates all these problems. So the bottom line here is realizing that if you want to file a memorandum of contract and an affidavit of contract, either one, follow the things I kind of laid out. Get the seller to join in with you on it. Whether it's one seller, husband and wife, two sellers, heirs, whatever it might be, to validate your contract and to substantiate your position. Now, if you do that, you're going to have a good memorandum of contract and an affidavit of contract, because now both parties have agreed to this, and are acknowledging the situation. And anybody downstream is going to have an invalid filing that doesn't have to be dealt with. But you've got to do it properly and correctly to make it work. But again, don't just file memorandums, guys, to file memorandums. I get what goes on in the marketplace out there. If you're an investor number 2 or number 3 along the way, don't just interfere in contract just for trying to make dollars out there because you ran a lead. It's not right and it's not good for our real estate investment business. So guys, I hope you found this video helpful. If you did, take a minute and like it. Don't forget to subscribe to our YouTube channel. And guys, we'll see y'all next time.